Huh?
We're now recording.
Are you there,
Hello,
Carrie?
Carrie, are you awake?
No.
Yeah, this is it. I'm on now.
Okay.
Is Wade Habe on here?
Huh?
Hey, do I hear you? We got
Ed, if you would remind everyone to mute by *6.
That's what I'm fixing to do. Everybody that's not talking, go ahead and hit *6 and mute yourself when you get
Come
ready
mute
to
this
say
for me,
something.
*6.
We were getting a lot of noise. Okay, you wasn't supposed to hit *6.
All right. Are we ready to start?
Yeah, let me ask you again, is Wade Habe on here? Okay, Carrie, go ahead.
Okay. We've been putting a series of telephone conference calls together. And there's been quite a few people that has been calling. We've gotten a lot of positive feedback. And it's a simple thought, but everybody says they know all about it, but they normally miss something on it. And what we find out is jurisdiction is it's not everything, but it's the only thing we use. Because if the court doesn't have jurisdiction, then it doesn't have a case. Now, for those of you that have been on it in the past, there's a way to go to the tax court, and the tax court will give you a court order signed by a federal judge saying that the IRS does not have jurisdiction. With that court order, you're able to go anywhere and have any liens, any levies removed. If they're taking your money, your check, your retirement, Social Security check, you're able to restore them. In the past, we've done all kinds of things in the past, and it never seemed to work, or it took forever. And 10 people would do it, maybe one would work. So far, I've been involved with about 500 people, and all 500 has worked. So we have a real good track record. Jurisdiction is so powerful, but yet it's so simple. This goes for anything. For those that are on the call tonight, it'll work for your IRS problem if you have one. It'll work for your property tax if you have property tax, and it'll work for practically everything. And what we're doing is you go on the United States Tax Court website, and on the website, on the far right side of it, there's a little tab that says Forms. You download the forms. It's a Form 2, a Form 4, and a Form 5. And you just fill them out, and then you mail them to the tax court in Washington, D.C. So I have to stress this because this is the biggest problem they have. You do not pay the $60. So you'll get a letter from the tax court, and it'll say you haven't paid your filing fee. Just shred it. Get rid of it. Don't worry about it, and leave it go. Then what will happen is the IRS will come back and say that they don't have jurisdiction because you're going to, on the forms, fill out, you never received a notice of determination and you never received a notice of deficiency. Because of that, the IRS can't do anything. They're dead in the water. Now, is Wade on here now?
Yeah, Cody, this is Wade. I just now got on. My phone was doing the same thing again, but it finally got in.
Okay, Wade, could you tell us what you received in the mail? What it said?
Okay, first I got a big packet. My wife got one and I got one. At the very top of the page, of course, it's got the respondent and then myself at the top. My wife got one, the same thing.
It should say petitioner.
Yeah, petitioner. At the top, not at the very top, but a little ways down, it's got motion to dismiss for lack of jurisdiction in bold black. And then they start naming several various sundry points that it's too much time has lapsed. Several other points. I'm out here in my yard right now. I'm having trouble with my phone getting good enough service in the house, so I don't have the document in front of me. Let me see if I can walk around in the house and my phone still pick up. I'll have it in front of me that way. Give me just a second.
Well, for those of you that are in front of a computer, you can go to U.S. Tax Court and go to docket inquiry, and then go to individual name, and then just put his name in, and you'll be able to follow along with what he's reading.
Terry, we'll need a last name for Wade.
Haby, H-A-B-Y.
His full name again?
Wade, W-A, I think, Haby is H-A-B-Y, I believe.
Yeah, H-A-B-Y, like boy.
Okay, and it's Texas.
Is there a middle initial?
No, you don't need a middle. You don't need a middle initial normally.
Can you guys just spell it again, because it's really hard to understand. I didn't quite get what you said. Just spell the man's name, please.
Yes. First name or last name is Haby, H-A-B-Y, like baby but with an H.
Okay, all right. All right.
And the first name is Wade?
Yeah, W-A-D-E.
Okay.
H-A-B-Y.
That's it.
And you'll be able to see what he got. It says on there, if you go on there.
So if you go to U.S. Tax Court, right?
Docket inquiry. Individual.
Hold on.
Is this your personal fucking call?
Now, odds are this would solve John's.
Docket inquiry, yep.
Okay. At the top there, it'll say corporate,
yes,
individual, or docket number. Go to individual.
Individual party name, yep.
Okay, then it opens it up, and now where it says last name, put in Haby. Where it says first name, put in Wade.
H-A-B-Y, Wade. Okay,
and then Texas, TX, and then hit search. And then hit search, and it'll pop right up.
Okay, there it is. It's
now go all the way to the far right, and it says view. Click view, and it'll open up the order he got.
Okay, I have 5 different things in front of me. Petition filed, request for place of trial, order for filing, motion for dismissal.
Oh, that's the one you want. You want the last one. That's the order of dismissal, and go all the way to the far right, and then click view, and it'll open right up.
I think there's 2 different ones.
Yeah, the very bottom one is what you're talking about, right? The very bottom one.
The very bottom may be this last letter I got from the tax court itself.
So you're talking about the order, is that correct, sir?
Yes, sir. That's right. You want the order. That's all that matters.
I pulled up the very bottom one out of the 5. You just view that.
Yeah, the one just before it was motion to dismiss for lack of jurisdiction. It's several pages long.
Yes, but if you go to the order, it's 1 page.
The order says on November 16th, respondent filed the motion to dismiss for lack of jurisdiction.
Okay, stop right there for just 1 second. Read that again. It says respondent. That's the IRS. Now.
Oh, wow, really?
Can y'all spell the guy's name again for the people that were a little bit slow at picking up what his name was? I didn't have a pen ready.
Last name Haby, Haby. First name Wade, Wade. And then
Haby like baby with an H.
Baby, yes, baby with an H. Now, what makes this so powerful is the respondent is the one that filed this order.
Right.
Okay, so the IRS filed a motion to dismiss for lack of jurisdiction upon due consideration. It is ordered by December the 18th. The petitioner has to go back and say, I don't want this dismissed. And then he'll get a final order that will say it has been dismissed. And if you go to the Internal Revenue Manual, all tax court rulings are binding and final. So
say that again, please.
Under the Internal Revenue Manual, all tax court rulings are binding and final. And this one here was asked by the IRS, the respondent. Once that happens, they don't have jurisdiction. It's forever over. If Wade gets a letter from the IRS for anything, all he has to do is take the letter he got, put it back in an envelope, take this order, which he'll get certified copies of it. It'll have the wet ink signature of the judge. Put it in the envelope and mail it back. That's it. It's done. Because they don't have jurisdiction to even send anything. It's over. Anyways, I didn't mean to step on you there, Wade. Go ahead.
On mine, I put from years 1982 through 2017. On my document, the original document, I put 1983 to 2017 and on.
Right, and what will happen? That's how the final order will come out.
Yeah, this order. They're ordering that owner before December 11th, 2017. Respondent shall file a supplement to the just referenced motion to dismiss and shall attach thereto copies of any additional IRS records, such as other types of transcripts, with explanation of relevant codes or certified mail lists that could support dismissal on the stated grounds. This supplement should also expressly clarify the apparent lack of any pertinent jurisdictional notice for the remaining years cited in the petition. I think that's what they're after now. It's the other years that they didn't mention at all.
Could you say that whole thing over again, Wade? Because it broke up a lot. You broke up a lot. If you don't mind, just what was that you're reading?
I will try. It's on the order.
No, they don't show that part. The order they show, but they don't show the IRS's motion to have it dismissed. They don't.
Yeah. Oh, that's what it was. The motion. Oh, that's where it says.
Yes.
The petitioner shall file an objection. That's what you read right now. The petitioner's objection.
Yes.
Would you mind rereading that again, please? Because you broke up and I didn't quite get it.
Okay, on this order, this is the court itself ordering the respondent to come up with some more documentation, basically. I'll read it. It says, this is the court ordering the respondent, which is the Commissioner of Internal Revenue. So they're ordering that on or before December 11th, 2017. Respondent shall file a supplement to the just referenced motion to dismiss and shall attach thereto copies of any additional IRS records, such as other types of transcripts with explanation of relevant codes or certified mail if that could support dismissal on the stated grounds. The supplement should also expressly clarify the apparent lack of any pertinent jurisdictional notice for the remaining years cited in the petition.
Did you get that?
Okay, what it's trying to tell you is the respondent has to come back and counter what the petitioner said. The petitioner said he didn't receive something that they had to give him. If they don't come back and do it, they're going to give an order of dismissal for lack of jurisdiction.
So that was the court ordering the petitioner, which is the IRS, to file an objection.
The respondent is the IRS, and they're ordering the respondent. Yes, they're ordering the respondent to come back and say, "Give me something to help me," and they can't, because in order to get a notice of levy, which is not a levy, or a notice of what is the other one? There's a levy and a
notice of determination, notice of deficiency.
Yes, you can't use those to get a lien or a levy. You have to get a 10-day letter, and you have to get a 23C. That's the law. They're not using that. So
what is the 10-day letter?
It tells you you're going to get a 23C.
In less than 10 days?
Yeah, you're going to get it. Or you get what it is they're telling you, here's what we got to have, and we're going to issue a 23C. But they don't use it anymore, and the reason they don't use it because they can't use a 23C, because the 23C has to be signed under penalties of perjury by an IRS agent and a judge. And the judge can't sign it because they don't have any proof. So by going this route, we're doing an end round, telling the court we didn't receive a notice of deficiency or a notice of determination. That's all we're telling them. So the IRS says, well, if I go in there, and if they go in there and say, well, we gave it to them, then that means they're admitting fraud. Then you can go back and you can break it off in them. So
you can go back and do what?
Break it off in them, because what they're saying is they defrauded you. They cannot use a notice of deficiency or a notice of determination to get a notice of lien or a notice of levy. They cannot use it.
Because it's not accurate. It's not done on the due process, because there's no.
That's correct. There's no due process. Right? Correct. So once you get your letter, it's not a letter. Once you get your court order, you call back to the court and get them certified. Then what you do is now you have a certified court order. You take it anywhere you want. You send it to the IRS. You send it to the Social Security. You send it to your retirement. You send it to your military pay, whatever pay it is. If they do not remove it, if you have to sue them, you're not suing them for taxes. You're suing them now for contempt of court. See, now it's always you're hitting them at a different angle. In other words, when you say, well, I don't want to pay taxes, you're considered a tax protester. I'm not a tax protester. I got a court order, and they're in contempt of court. They can't. That's a fight you can win, and that's a fight they cannot win.
Right. It's so blatant. It doesn't have to deal with 70,000 pages of tax code. It has to deal with an order that's being violated. One-page order.
There it is.
This is interesting here. This is Wade again. On the letter that I got from the IRS, motion to...
Don't forget to subscribe to this YouTube channel. Don't forget to like this video. And don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. Here's the front page of the channel. The bottom arrow is pointing at the subscribe button that's normally red until you click on it, and this one turns white after you subscribe. The top arrow is pointing to the bell. Now, the bell doesn't show up until after you click the subscribe button, and then the bell will show up, and that way you can be notified of new uploads.
Dismissed for lack of jurisdiction. It's got points 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and several others. On number 11, let me back up. Yeah, number 11, I'm going to read it. It says, respondent has diligently searched his records and contacted IRS personnel in an attempt to determine whether any notices of determination have been issued to petitioner. Based on this diligent search and based on a review of respondent's records kept in the ordinary course of business, when respondent issues and mails a notice of determination to taxpayer, there is no record, information, or other evidence indicating that a notice of determination by Internal Revenue Code 6320 or 6330 has been mailed to petitioner.
See, there's the violation right there. So the only thing they can do now is tell the judge, hey, dismiss this case for lack of jurisdiction. And he went all the way back to 93. So his order is going to say, his final order is going to say, the court, on the petitioner's own motion, this case is dismissed from 1993 all the way to 2017. Because the IRS does not have jurisdiction. And the reason they don't, because they violated their own code.
Here's another interesting part in this same document on point number 3. Respondent has searched his records and determined that petitioner has outstanding tax liabilities for tax years 2003, 4, 5, 6, 7, and 8. Respondent has searched his records and determined that petitioner's liabilities were assessed from substitutes for returns for tax years 2003, 4, 5, 6, 7, and 8. In other words, they filed for me. They just made up a bunch
please,
of stuff.
You broke in the middle of that. If you don't mind, Wade, read that again, please. Real slow, real loud.
Okay, here's it. Respondent has searched its records and determined that petitioner's liabilities were assessed from substitutes for
what? For what?
Substitutes for returns.
SFRs.
From substitutes for returns for the tax years, it names the years. They substituted. They made up returns for me on their own with nothing to back it up, just pulling figures out of thin air.
Oh, really? Wow.
Really? Wow. Jesus Christ. You're an idiot.
And then they sent copies of each year. I've got them.
If you go to the Internal Revenue Manual, it tells you in the Internal Revenue Manual, the substitute for return cannot be done for a 1040. So now they're telling you we broke the law. So when he gets his final order, he's going to be able to use that anywhere he goes to stop anything they've done and reverse it.
I've got one, and my wife's gotten one that's close to the same. Now, this order, the very last document, has only been, my wife's only received it. I haven't received one yet. They probably already filed it, but I haven't received it in the mail.
Okay. Now, the other thing you can do is you can write a letter to the United States District Court in Washington, D.C., asking that court that you're having problems with the IRS. You need advice. They're going to write you back to say that they don't give legal advice. Then you just keep that going. It's going to take 5 or 6 letters. They will eventually say, get an attorney. Then you tell them, I've got an attorney. The attorney told me to contact you. Keep that going however long it takes. Then they will end up writing you a letter saying, well, we can't help you because we don't have any jurisdiction in IRS issues. The reason you want that is if the IRS decides to charge you with something, they're going to take it to the United States District Court. If you had that in your hand prior to that, when you showed up, you can then present that as evidence that the IRS doesn't have the IRS does not have jurisdiction in the federal district court. Now they're dead in the water. What we're trying to do is we're trying to build a wall around you so that no matter what happens, you're already covered. Good. And all you have to do is write a letter to now understand, they're going to tell you they can't help you because they can't give legal advice. You write about, I'm not looking for legal advice. See? And it doesn't have to be but 1 or 2 lines.
They'll have to get back. They possibly have to refund, and I can sue her former employer for taking part in blah, blah, blah.
Yeah, I don't understand what that guy's saying.
Michael?
Okay. Does everybody now kind of get their mind around the jurisdictional thing with the IRS? I guess by the silence that means you are.
Yes, I do. I've got just a few really basic questions about this form, but I don't know if now's a good time to ask it or if I should wait.
You can go with the property tax.
All right. Go ahead and ask it.
Okay. This shouldn't take but a second. So just to confirm, the mail-to address is the United States Tax Court, 400 2nd Street, Northwest Washington, D.C., 20217?
Yes.
Okay. Where it says first, middle, last, if you've been getting notices from them, are you going to put the middle initial or just the full middle name?
It doesn't matter. You can put your first initial. That they know who you are, but you can put your first name, middle initial, first, middle, and last. I mean, however you put it down, that's how it's going to show up on the order. So, if there's a reason for you to do it, just do it the way that's going to help you. If they're after you now and they're using your first, middle, and last, then get your order the same way that they got you on your letter.
Thank you. That's what I had written down. Just confirming. Okay, I get send no money, but I see an application for waiver of filing fee. Do not do that either.
No, do not do that do not do that. And the reason you don't want to do that is the IRS, the tax court is set up in 2 areas. One of them is judicial and one of them is administrative. When you pay the $60 or ask to have it forgiven, you fall under the administration side of the court, and you end up with a different deal. If you want to see how that works, has anybody ever heard of Joe Bannister? Oh, yeah. Joe Bannister's out of Nevada. He was doing this, and then he got an attorney. The attorney told him to pay the $60. When you get it, he's got probably 60 filings. He was doing really well. All of a sudden, he paid the $60, and the court turned on him. He was found guilty. He eventually got it overturned, but he had to go to the appellate court to do it. So I'm telling you to stay away from all that. Don't pay the $60.
Yeah, they sent me a letter saying an order to pay the $60. So people will get an order from the court, but you still don't have to pay it.
No, you can't pay it. Just shred that. Get rid of it. Don't worry about it. If it comes back and they say, well, we're dismissing this for not paying a filing fee, then do the whole thing over again. It's not going to hurt anything. Just do it over again. I mean, but I've done close to 500 of these, and we've had almost no problems. Okay. And with it, we're able to go back to any court with the jurisdictional order from the court. We, like I said, we go back to the court and get certified copies, and we're able to release some liens, release some levies, have them taken off of your home. If the IRS is taking your Social Security check, we're able to reverse that. If you went to jail and you're a felon, you now have a tool. You can go back and have that taken away. Then you do that. Then you can go with it and get your. If you went to jail for 3 years, however much they pay, there's evidence there for you to go to take them to court and show them, hey, you put me in jail and I wasn't supposed to go because you didn't have jurisdiction to do so. So there's a whole lot you can do with this, with the documents that you get from the tax court.
Okay, just a few more questions.
May I ask you a question, please?
You may.
Hello. I did go to jail because of the OID, and now I'm on probation and I need to pay a fine. If I have this letter, does that mean perhaps that the fine that I'm supposed to pay while I'm on probation is obliterated? Because I really didn't like to go to jail because of the OID that I did.
Okay, now my question is, who's asking you to pay the fine?
The court, the federal court.
Okay, but it has to do with the OID. That's an IRS issue. Then you can take the jurisdictional document to the court and say, hey, you're telling me to pay a fine and the IRS didn't have jurisdiction to tell me I owed the fine. That's the only argument. Let the court say, well, it doesn't count in this case. Now you can object. Now you can appeal. You can appeal and get it out of the hands of those that have you chained to the floor. Then you can get into the appellate court. Now you and let the appellate court overturn it. Then you can go after them because they didn't have jurisdiction. They made you do this. You went to jail. Now you have, this is your evidence. There's only two things that are allowed in court, facts and evidence. The facts are they don't have jurisdiction. The evidence is here's a court order telling me so. That's all you need. And now you can do with that, you should be able to get that taken care of.
Thank you.
Now you understand that I'm not telling you to do that. I'm not an attorney, and I'm not trying to get you to do anything, okay?
Absolutely. Thank you.
Okay. I just want you to know that. That's all. Okay.
Sir, your name is...
So it was more than 3 years ago, so the statute for wrongful imprisonment expires after 3 years. So would I go for retribution under like a civil liberties infraction or something of that nature, like a civil rights, a deprivation of rights type of thing?
Okay. What you're going to do is, let's say you went to jail in 2005. Go back past that. Go back to 2000. That means the IRS did not have jurisdiction in 2000. Now it's fraud. See, the statute of limitations for fraud is different.
Yeah, it never expires. There's no expiration or statute of limitations for fraud.
Okay, now you can go back under fraud. The reason I went to jail because that was fraud involved. Fraud was they didn't have jurisdiction. They're going to say, well, we didn't know. Well, ignorance of the law is no excuse. Now you can go back under fraud because you have a court order saying the IRS did not have jurisdiction all the way back to 2000 to 2017. Okay? If you went to jail in 99, then go back to 91.
I understand. I went to jail in 2010. I understand what you're saying.
Okay. Just go back and get it. Now it's not about statute of limitations. It's about fraud.
Right. Brilliant.
Then when you have that removed, now you have more evidence. Then just keep moving forward. With this document, we're putting the kicking shoe on your foot. The problem you're going to have with this document is you start kicking, you're going to get wore out because it's going to be able to do anything you want it to do. You can go to court, get your money back. You can do whatever you want to do with it. Whatever you can come up with. It's
all under fraud at that point. It's all under fraud, right?
There you go. There you go. See, it's all under fraud because they knew better. Or if they didn't know better, then they shouldn't be in that job.
Where would you bring it? Where would you bring the complaint, or how would you bring the complaint regarding false imprisonment, or say when someone takes, there's been a levy of assets because they,
Okay.
So they've taken your money.
Okay.
What court would you do? How would you go and what would you do for your remedy?
Okay.
Now that you have the jurisdiction letter.
It's not a letter. It's a court order.
Court order. I'm sorry.
What court put you in jail?
Federal court for failure to provide books and records.
Now, what I would do is I would write a letter to that court in Washington, D.C. When they come back and tell you they don't have jurisdiction, now the court didn't have jurisdiction and the IRS didn't have jurisdiction. Go to the federal court and file a complaint on the judge. See, now you've got evidence that it's a conspiracy. Do a Title 42, a 1983 suit against the judge because it's a conspiracy. Do a what is that? There's a conspiracy lawsuit. You can go get an attorney now. Let them file it for you because you've now got a winnable case. Why? The IRS didn't have jurisdiction and the court didn't have jurisdiction, and you did time. That's big. That's huge because they falsely imprisoned you and they used fraud to do it. And there are statutes out there that says if they did that, you are entitled to be compensated for. What we have.
Yeah, that's great.
We have to break them of it. If you have a kid that he's unruly, you don't just let him rule. You pull out the switch if you have to, and you spank him with it. Well, we have to spank the IRS, but we have to spank them hard because they're getting away with it for a long time. All I'm trying to do is give you some tools so that when you go into the woodshed, you've got something to fight back with. Because what's happening is when you go to court, the judge is going to say, well, you have to have an attorney, blah, blah, blah. I'll just tell you a quick story. In 1993, I was involved with 18 people. 18 people got picked up, and I was one of them. We went in front of the grand jury to be indicted. My last name starts with a Z, so I was the last one. They did them in alphabetical order. The first 17 people went to jail for 8 years to 50 years. Several of them have died in there. Some of them are still there. He came to me. I challenged jurisdiction from the minute I walked in until the minute I left. And what they said was, let the guy go because we're so confused we don't know what they did. Because every question they asked me, my answer to them was, man, I'm glad you asked me that. Do you have jurisdiction to ask that question? Yes, I do. Well, then show me. I'm just one of them kind of guys. I don't believe you. Well, then we'll just skip that question. Then they'd go to the next question. Everybody went through this, was there 45 minutes. I was there for 9.5 hours. At the end of the 9.5 hours, they sent me home because they were on question number 4.
Wow.
And the reason for it was, see, when you go to court, and think about this for a minute. If you want to get a divorce and you go to the JP court and he gives you a divorce, what do you have?
You have an order.
He gives you a decree. Yeah, he gives you the order. He gives you a decree and everything. What do you have? You got nothing. Why? You didn't go to family court. Why? JP court has no jurisdiction in divorce. So you have to go to the family court. Why? That's the way it's set up. See? In other words, you go to the court that has jurisdiction. If they bring you to the wrong court, and they always do, I took about 400 cases and I went through them where people went to court and went to jail. out of the 400 cases that I looked at, and I just randomly picked them, 400 cases, all 400 were in the wrong court. They were in a court that had no jurisdiction.
Now, why do you think that is?
Because they can get a conviction. You don't know any better. So if you go to the wrong court and they can get a conviction, that's what they're after. Why is it that the United States District Court does not have jurisdiction in IRS issues? The IRS takes you to the federal district court 100% of the time. They have no jurisdiction. Why do they do that?
So they can get a conviction, right?
Okay, because that's correct. Because if they don't have jurisdiction, no matter what you say, it doesn't matter. So what law are they using? What law are they using? It don't matter what law they use. Why? There's no jurisdiction anyways.
Yeah, they're using color of law.
It's okay, but color of law isn't law.
No, absolutely it's not law.
See? But they use it because they don't have jurisdictions. Now, if you don't know that, that's your fault. I'm telling you right now, write a letter to the United States District Court. It's 3330, I think it's 333 Constitutional Avenue or something like that. It's right on the internet. Just send it to them. Don't worry about it. They'll write you back. Just keep it going until you get the letter signed by the judge saying the United States District Court has no jurisdiction. If you had that letter when you went to court, what would they say? Well, we have it, but they don't. Well, then let's indict them. Then what you do is let's subpoena the judge in. Let's see what he says. See, if they don't have jurisdiction, they have no case. Now, you can challenge jurisdiction at the beginning, middle, and end.
Anytime it's challenged, I think the law says anytime it's challenged, it must be rebuted by the court.
There it is. Now, what other law is like that? Name me one other law like that. So it must be pretty important. But we're going in there, so we go in there and we say, well, under Title 6331A, I'm not a federal employee. So what? They don't have jurisdiction anyway. It doesn't matter.
The whole thing's a farce.
It doesn't matter, see? So, but you're going to go to a court. I promise you, if the judge gives them their indicts you and he signs the order, they're going to pick you up and put you in jail. But that court don't have jurisdiction. You never tried it. Well, they know better. Doesn't matter whether they know or not.
Our blog is texasrepublic.wordpress.com. Our website is thetexasrepublic.com. Our email address is oneyellowroseenterprises@gmail.com. Our YouTube profile is, this is the link, because YouTube doesn't allow us to have a customized URL until we have over a certain number of subscribers. And follow us on Twitter at Texas Republic for You and at We Are Texians.
All I'm telling you is there were 18 of us. 17 in a row went to jail. I did not. Why is that?
Because you challenged the jurisdiction of the court.
Okay. The other guys, why didn't they do it? Because they were scared. I was scared too. They offered me 55 years. I told the judge, if you have jurisdiction, you don't give me 100 years, you can kiss my butt.
Did the other people know about the jurisdictional challenge?
Of course they did. I talked to each one of them.
Wow.
And each one of them said, I'm not going to do that because we have protection, because we're not a federal employee. We're not this. We're not that. See, it's not about you. When I accuse you of something, all right, I accuse you of being whatever, okay?
You make an accusation is what you're saying, right?
That's it. You don't have to prove anything. See, they say you're a taxpayer. I don't care what they say. Prove it. I'm just going to sit down. Why? They don't have jurisdiction. See, I can say to you, are you married by any chance, sir? Right?
Yes, I am.
Okay, can you prove it?
I have a record of it. That's about.
Okay, that's fine. So prove you're not married. See, how do you prove a negative? That's what we're doing. By going into the court, challenging jurisdiction, you're making them defend a negative. See, if I was to ask you, have you stopped kicking your neighbor's dog? What is your answer?
Yeah, but how is going to court? How is going to court defending a negative?
How? Because you're in a court that doesn't have jurisdiction, and they're telling you you're here for willful failure to file. So you're going to say, I'm not one that has to file. There's your negative. You're telling them what you are. It doesn't matter what you are. They're accusing you of something. They have to be right. So they
have to have that. In order for them to be right, they have to have the jurisdiction to accuse us.
Period.
Right?
It doesn't matter. That's correct. What state are you from?
I'm Florida. I'm Clearwater, Florida.
Okay, so you're in Florida. You get a letter from Ohio, and it says you owe us $500 for property tax, and they list your address in Florida. What are you going to do?
Yeah, ignore it. Throw it away.
Why would you do that? Why wouldn't you pay it?
No jurisdiction. Absolutely.
There it is. See? So if the IRS says to you, come to court for willful failure to file, you show up. Does this court have jurisdiction? Yes. Then I'm going to sit right here and let you prove it to me. Once they prove it to you, now the question is, does Title 26 have anything to do with you in a court of competent jurisdiction? Absolutely not. Why? Because you're not a federal employee. Now it matters. See, in Texas, we have a constitution, and it says, Texas Constitution is the supreme law of the land. Is it the supreme law of the land in Germany?
No, just in Texas.
Okay, see? Now, if I have jurisdiction on Texas Constitution, I'm a judge. I go to Germany. I'm going to try somebody in Germany under Texas Constitution. It doesn't matter. It don't work that way. I would have to use German law. Why? Because it's Germany. See, so if the IRS is taking you to the United States District Court, and the District Court doesn't have jurisdiction, what law are they using against you? Tell me, what law are they using?
They're using color of law. They're using fabricated law.
Okay, so then go to prison for that. Go right ahead. If you want to go to prison, go. See what the problem is? They're using something that doesn't even pertain to you. Why? Because they don't have jurisdiction to issue it.
Right, so therefore anything that they've done in the past is in violation of that, becomes violated, right? It's vitiated. All contracts are vitiated under fraud, right? What is entered crooked? What is entered twisted ends twisted is the axiom, right?
That's correct. See, now when you get your court order, it's not a letter; it's a court order. The IRS does not have jurisdiction from 1993 to 2017. Now, when you go back to the court, said you put me in jail, and these pricks didn't even have jurisdiction.
Right.
Now what are they going to say? Well, they did then, not according to this law. Who's lying? Are you lying, or is the tax court lying?
It's the federal judge lying, right?
See, there you go. The tax court has jurisdiction on the IRS. The tax court, and if you read what Wade just read us, it says the IRS said we don't have jurisdiction. So now you have a court order signed by a judge where the IRS says they don't have jurisdiction. Tell me, would that be any value to you at all?
Yeah, that might be somewhat useful, I'd imagine.
See, that's right. See, and I'm telling you to go back as far as you need to. Well, I need 2005. Then go back to 2005.
Well, I filed last week. I went back to 1979.
That's okay. Well, that's fine. You know, that's fine. And when you get your thing, it's going to say they never had jurisdiction. That's fine. So if you get a letter in the mail and they say to you, we're going to take you for willful failure to file. Take the letter, put it in an envelope. Take your jurisdiction court order, put it in an envelope, and mail it back to them.
Oh, absolutely.
See, now it's over. I did this, and I think.
Would you recommend doing an administrative, so say they did incarcerate a person, right? Now, would you recommend they do an administrative process, to just have a hearing type of thing where they meet, or would you go and sue them for fraud?
Go and meet first, and then you'll feel it out. You go there.
To try to exhaust the administrative remedy, right?
Okay. once you exhaust your administrative remedy, then you go and break it off in them. Now it's over. Now we're going to put.
They haven't complied at that point. At that point, they haven't been honorable and settled it administratively, right? They've pulled punches.
Correct.
And
see now, let me explain to you. I was about 12. My father moved. We moved from one town to another. I'm from Michigan originally. We just moved across the state. So I was the newbie.
Right.
I did that. Okay. So the kid walks up to me and says, "I see you're the newbie." He said, "My name is." So he gave me his name. He said, "Everybody pays me their lunch money, or I beat them up."
Oh, the bully.
So how do you know
I missed the bully.
Right. I said, "How do you know you can beat me up?" He says, "Ask anybody." I walked over there and I kicked him in the groin as hard as I could. He hit the deck, fell down like a sack of potatoes. I turned his pockets inside out, and I took all of his money, put it in my pocket, and I went. 3 days or 4 days later, he walked up to me and said, "You cheated." I said, "How did I cheat? Did you give me the rules?" He said, "What rules?" I said, "That's right." So I kicked him again. See, what I mean is that's what they're doing to us.
Yeah.
Then when you get into court, here's what they say. We're here by federal rules of civil procedure. Now, here's my question. That's not a rules court. That's a court of law. So you're in the wrong court. They're telling you you're in the wrong court. So the law.
Well, wait, you're looking for a court of law, and they're saying that we're a court of civil procedures, rules and civil procedures. I might have misunderstood that.
Yes, that's what it said. Because they're going to say, well, we're here today because he broke the law. Willful failure to file. Under the federal rules of civil procedure, I have a right to bring him here. That's what they tell you. So now you're there and you're fighting. Well, yes, sir, Your Honor, I'm not a taxpayer. I'm not a. That isn't what you're arguing. Then they'll say, well, he's stating a claim that relief can't be granted. See, they're telling the judge, this guy's a nut job. He don't know what he's talking about. So
well, if you're doing I'm not this, then you're on the defense. And what you're recommending, if I'm not misunderstanding this, is that you're recommending that we go on the offense and say,
okay,
do you have the jurisdiction to even be talking to me?
Do you even have the jurisdiction? Yes, we do. Then prove it to me. Walk up to them and kick them in the groin right off the bat. Do you have jurisdiction? Bam. When they stop crying, then and I don't mean that physically.
No, I know. It's conceptual understanding, right?
What you're going to do is you're going to ask for jurisdiction. So think about this for a minute. Oklahoma City, Oklahoma, comes and picks you up, takes you to this Oklahoma City County Court, and charges you with willful failure to file. How are you going to fight that? Tell me how you're going to fight that.
What jurisdiction you have to even have standing? They have no standing with that assumptions.
Okay.
With those elements, right?
That's right. How could they? You live in Florida. How in the world could they? So the question is, if the federal court doesn't have jurisdiction, they're accusing you of being willful failure to file. Here's the problem.
Actually, like when any lawyer files a suit,
yep.
they assert that they have standing to do so, right? Because without standing, they can't file a suit.
Okay, but they.
And in essence, no attorneys have standing to file a suit against you. Fraud and fraud.
Every attorney has standing to file a suit against you, every single one of them, because under the Texas Rules of Civil Procedure, it tells them they have it.
Yeah.
See, that's a rule. But what law did I break? Well, you broke statute 123. That's a law. They're going to take you to someplace else and say, under Texas Rules of Civil Procedure 41, we're here today to accuse him of breaking the law. See? I went to court and I was charged with something when I got there. It was a JP court. In our Texas, a JP, there's a statute that says he's not a judge. So he's a justice of the peace. So he says, will you waive your rights to a jury trial and have a judge trial? I said, absolutely, I'd love to do that. He said, okay, then I'm going to try it. I'm going to try the case. I said, sir, I object. He said, what are you objecting to? You're not a judge. He says, well, according to Rule 46, I am a judge. I said, I'm not in a rules court. I'm in a court of law. So go ahead, find me guilty, because when I appeal, we'll appeal it. He just threw the case out. Why? Because he doesn't want to argue that. He don't want that on the book, so he just threw the case out and said, here, it's dismissed. Okay, thanks. Because he's not a judge. What?
Sir, my name's Jay, and I've been listening for quite some time, and you're on a subject that's very close to my next question, and I just wanted to get this out.
Go ahead.
Right now, I'm in a case with a quiet title mortgage / eviction case.
Yes.
So what they're trying to do is get service by publication, because they're saying they haven't been able to serve me, so they've come forward. So what happened was, without going into a long story, I was able to defeat that, and I put in a motion to dismiss. But I was able to defeat it upon faulty service because it never happened. Okay? So I put in a motion to dismiss. The opposing counsel said, well, he came back and he said, well, according to this official code of Georgia annotated, which now I'm seeing what you're saying because there's rules and law, and I'm seeing this is code.
Yep.
So if it's official code of Georgia annotated that he's using, he says, according to the OCGA, official code of Georgia annotated, this guy resides, which is an assumption, in Georgia, and we have jurisdiction as soon as we do service by publication. Here, Judge, sign this order. So the George is probably going to sign it here shortly, and in 60 days, if I don't answer with something, then it's going to be again, the court's going to have jurisdiction. So in regarding service by publication, do you have a way to beat that, or is it the same thing that you've been saying?
Okay. It's the same thing I've been saying, but let me just say this. I can only tell you this in Texas. In Texas, we have JP courts. They're the bottom. Then we have county courts. Then we have state district courts. What I'm doing on that, they always go to the county. The county doesn't have jurisdiction. That's why they go there, so they can get what you just said.
Yeah, this is the county court.
Okay, then go to your state district court and file a quiet title action or something. Once you do that, everything below it stops. It does here. And that's how we're handling the foreclosures. We're going to a superior court, making our claim in superior court, and then the superior court, we take that and serve it to the lower court. The lower court has to sit down because they have no jurisdiction. We cut it off right there. Then we can beat them in the superior court because the superior court asks for certain documents that lower courts don't. So that's how we're handling it. So to answer your question, that's why they're doing it the way they're doing it. I don't know everything about every state, but go to a superior court and file some kind of a quiet title. And by doing so, that will they have to come into the higher court, and then there's part of your argument.
What does the quiet title document do?
Well, because a quiet title, they don't foreclose anymore on if you're not paying the payment, they're not foreclosing on the mortgage because it's been sold so many times. They're foreclosing on the title. Who has superior title? Who owns the title? Who has the biggest title? And so the quiet title, what you're doing is you're saying my title is better than everybody's. Now, the judges, you're going to go in and show what title you have, and then the courts, they're going to bring in theirs, and yours is going to be greater because you signed for it. What they're doing in Texas is they take a trustee, and the trustee does a trustee's deed. Now they're foreclosing on you in county who doesn't have jurisdiction with a trustee's deed. Where in Texas, you got to have a warranty deed. So the warranty deed is higher than the trustee's deed. Anyway, so we're just going to a superior court challenging the lower court's ruling. Now the lower court's ruling it doesn't matter. It's all done. It's over until it's ruled. Then if they rule incorrectly, then you can appeal. See, you can always appeal. Everything they say you can appeal. They tell you to put up a bond, put up a bond. Then if they don't like it, get a bond hearing. The bond hearing will tell, well, then move it up. Keep moving it up. And eventually you'll get into a court. You may be the Supreme Court, but you'll get to the court that can make a ruling. So I don't know if that answered your question or not. But if they're taking you to a court that doesn't have jurisdiction because they can get that way, they're only going to look at one thing. See, in Texas they have a what they call a forcible detainer, which is occupancy. So they take you to a JP or they take you to the county court, and he can only look at occupancy. What about the title? I can't look at that. They can only look at the occupancy. So they'll rule however they rule. They'll give you some, and they don't. So they'll rule against you under an occupancy. What does occupancy have to do with title to the house? Nothing, but they can't look at it because it's outside of their pay grade. And that, I suspect they're doing that there too.
That's exactly what they do.
Yeah, this is Raymond from
Okay, I have just 3 quick questions about the form, and then I can just practically buzz off. So on the back of the date, if you go back to the date that the born on date to the current year, then there's not a problem with that, correct?
Okay, so you're going to go back on you're talking about the IRS, going to the IRS?
Yes, the tax court form.
Okay, no. Why would you do that? That's ridiculous. You when you were born, you didn't have a job. You didn't make any payments. The IRS really can't go back more than 10 years. They have a hard time. They do it from time to time. So go back to at least 2000. Now, if you have an issue in 93, then go back there. I recommend that everybody go back to at least 2000. That's 17 years. If they don't have jurisdiction in those 17 years, how did they get it wherever? But most people don't have a problem back in the 60s.
Okay.
Because they weren't working, so you don't need that. But if that's what you want to do, go do it.
Okay, and then all you have to send in on the tax kit is the 2-page
petition.
Form 2. It's the 2-page petition. The tax court form 4 and the tax court form 5. Mail that to that address. Then it's just sit and wait. Correct?
That's correct. And on the form 2, you're going to check 2 boxes. The reason you're there is notice of deficiency and notice of determination. And then the next 3 questions ask you, why are you questioning it? NA, I never received a notice of determination and I never received a notice of deficiency, and you put all the years you want.
Okay.
Now, let me just explain to you how jurisdiction, because what you said brought up a question. I want you to think about your birth date, okay? When you were born, okay? On the birth certificate, it's a certificate of live birth. It says the day you were born. So is a born date and a birth date the same date?
No.
That's correct. So see? So now you got that. That's a screwed up deal. So everything that they're doing under color of law. They'll tell you, what's your birth date? When you tell them, that's wrong. Because that's not the date. You're giving them your born date. So see, everything they do is skewed. You already know that going in. So what I'm trying to do here tonight, if you will, I'm trying to give you something that you can fight with the IRS without having to spend a fortune, without having to go to jail. And if they took you to jail, you now have tools to go back and get compensated for that.
Right. I have one more question, and then I'll yield the rest of my time for the rest of the night because I'm sure everybody else has a lot of questions. My first name is Jay. What was your first name?
Steve.
Your name is Steve?
It's C. Yours is J. Mine's C.
Okay, C. Okay. You on the last call, you gave an email address where I could email you, and I just wanted to know if I could repeat that. What I think I've got here because I've got something I wanted to email you, if that's okay. Can I repeat that email that I think I got?
The best way to do it is, if Ed doesn't mind. Ed, do you mind if they contact you and you give them my stuff one at a time instead of everybody at once?
That'll be just fine. You won't
on the whoever sent you the invitation tonight, on there has Ed's email address. Email him and then he will do it one at a time. I field now, because I've been doing these, I field about 60 calls a day.
Right.
And,
right.
I get emails about 40 or 50 a day, and it's more than I can do. So I don't, if you have a question, get a hold of Ed, and then Ed will answer what he can. If not, then I will get it.
Okay. I don't know if the guy with me has his email. So, Ed, can I get your email?
Yes.
Okay.
REPTX777@att.net.
Let me read that back. Thank you, Ed. I do appreciate it. It's REP like rep, TX like Texas at 777.att.net.
Right on the money.
Thank you. Thank you very much, Ed. I'm going to email you here shortly. So you know it's me. My name's Jay from Georgia.
Okay.
Great. Thank you. Okay. Thank you, everybody. I'm shutting up now.
Oh, okay. Does anybody else have a question that we can get? Because we're getting.
Yes, I do, Steve. Hello, Steve. My name's Stanley. Can you hear me?
Who are you?
Stanley.
Yeah, I can hear you.
All right, my name's Stanley. I'm from Rhode Island. I own a business in Massachusetts. I haven't paid taxes since 2007. Now they're coming after me for taxes. Is there any way I can resolve them coming after me for taxes? Because they asked me. They told me I owe $71,000.
Okay, now who's coming after you? The state or the feds?
The state.
Okay, the state's taxes are based on the federal, correct?
Correct.
Okay, if you do this, you're going to get a court order that says the feds have no jurisdiction. Then you're going to mail that to them, telling them, since the reason I don't file, because the feds don't have jurisdiction, so you don't either. And that's how we're handling the state problem. States are really, really tough, but we're starting to make a little headway with it because we're using the court order from the tax court saying that the IRS does not have jurisdiction. So in your book, in your Massachusetts book, page 1, it's going to say all Massachusetts income taxes are based on the federal tax book or federal taxes. They don't have jurisdiction, then what does that tell you about Massachusetts?
Okay, so that goes on the same thing as regular IRS taxes then.
That's exactly what they say. That's what they're saying. I looked at 6 states. I looked at Ohio, Michigan, I think California, and I think Florida. No, Florida doesn't have it. There was one other one, Georgia, I think. Anyway, when you open up their booklet, it says on the first page, all income taxes for the state of, you figure it by using your federal tax return. Now, here's the problem. If the feds don't have jurisdiction, what does the state have?
Obviously no jurisdiction. But
That's
Massachusetts isn't a state. Massachusetts is a commonwealth. Does that make any difference?
Okay. So no, it doesn't, because read your book. It's going to tell you. I don't know that, I haven't looked at it, but I would suspect Massachusetts, the Commonwealth, says the Commonwealth of Massachusetts income taxes are based on your federal tax return.
Yeah, I live in that. What it actually says is it applies to those that have an obligation under the federal code, right? So if you have to pay a federal income tax, then you have to pay a state income tax. If you're not liable for a federal income tax, then you're not liable for the state income tax.
See?
Okay.
Yes.
This is
does that make sense? Yes, ma'am.
I don't know
got a lady wants to say something.
Yes.
It's that way in North Carolina. They tie it completely to the feds. It's 100% tied to the feds.
Okay, so if the feds tell you, if the Internal Revenue Service gives you an order that they do not have jurisdiction, when the state writes you a letter, you send that to them saying, well, if they don't have it, I'm confused. You tell me how you got jurisdiction if they don't. See, now the argument's different. It's not about taxes. See, we're always saying, well, I'm not going to pay my taxes. You're offending the person because the person on the other end of the phone is saying, here's what they're hearing. I don't want you to get paid. That just makes them mad. So what I do on everything, I never tell them anything. I ask, hey, since the feds don't have jurisdiction, do you have it? Let them say yes. Great. How did you get it? Because your own book says it comes from the feds. How did you get it? Now what they've got is, see, now they got it, well, that's not what we meant. Well, what did you mean? Then why did you write it? See, everything that I do, I ask. I never tell anybody anything, okay?
Mm-hmm.
Does that make any sense? If the feds don't have it, how did the state get it, if that's what the state says, or the Commonwealth, or D.C., or whatever it is that you're talking about?
Right. I understand. Okay, beautiful. Thank you.
That's no problem.
I want to ask a question. Can I ask a question?
10 minutes.
You may. Go ahead.
All right. I wanted to ask what happens if, say, for instance, you're married to a lawyer and the CEO, and you do it and get a letter, and he doesn't want to do it. Then are you liable for his taxes, or is he just liable for his taxes?
Okay. In Texas, we're a common law state. So if my wife owes, I owe. I don't know what state you're in. And may I make...
It's California. It's California. California.
Okay, why would you marry an attorney?
Oh, good question, but he's very nice.
No, I'm sorry, but the devil's not nice.
I said a good question, but he's very nice.
What I'm saying is...
California is also community property.
Okay, then you're going to have a... See, I don't know what California is. I know Texas is. I know Michigan's not. Ohio's not. So what you're going to do is you're going to get that. But your husband, as an attorney, that's part of being an attorney. He cannot not pay. He cannot not pay because they'll pull his bar card from him because he won't pay. That's part of it. He
doesn't care whether he has his bar card anymore, really, because he's more a CEO.
Well, then that's between you and him. I'm not going to tell you that. I can't tell you that. I don't know. That I don't.
But is California common law, or what is it? Does somebody know?
Somebody said it was. Somebody said California is.
Okay.
So that creates another issue.
Carrie, that's not law.
Community property. Yeah, community property.
Yes. Community property. I did say common law, but community property, yes. That's what I meant.
Thank you.
It's no problem.
Gary, quick question about... Gary, we got about 10 minutes, so we got to get the done.
Okay. Does anybody else have a quick question that I can try to answer? Yes.
You've mentioned
I have a quick
Form
question,
2
Anna.
tonight.
Okay.
And I just wanted to ask if Form 2 or Form 1 is appropriate.
Yes, Form 2 is now the new number 1. So 2 is simplified. 2 is very easy to use. Just use 2, you'll get it's better. 1's the old one. They're very, very similar. Yes, 2, 4, and 5.
Thank you.
Okay, now, ma'am, go ahead and ask your question.
Yes, you were talking about the jurisdiction for taxes. So, yes, I understand that state gets their authority from the Fed if they don't have it, but with that, I've never heard of that before. So, where does the IRS get their authority from?
Well, they don't get it. That's what this is going to tell you. The IRS doesn't have it. See, the IRS doesn't have it, so they're telling you they don't have it. And because of that, what we're doing is, we're able to build a wall now. If they don't have
Where do they say that they don't have it?
Because you'll get a court order. The IRS will come back and say they don't have jurisdiction. The IRS will tell you that in your court order. That's what the court will give you.
Okay, is it because that they're just a service, they're in a incorporation?
Well,
they're an incorporated company?
The IRS is incorporated under the IMS. So, it's kind of like General Motors and Ford. They're both automobiles. They're both incorporated. They're both exactly the same, but the parts don't interchange. So that's basically all I can tell you. Now, if you go on the United States tax court, go under docket inquiry, and if you want to, get a hold of Ed, and he'll contact me, or you can get my email, and I'll send you a half a dozen names, and you can go on there and look, and you can read you can follow right along. and you'll see what it says. I mean, put it.
My book on 9/11 in the world today. It also shows under the Secretary of State of Delaware that the IRS is a private corporation. It tells where it is and what the filing numbers are and all that. So it's 9/11 in the world today.
Well, thank you. But because they're incorporated, I have a copy of that. That
has nothing to do with it. Okay, the incorporation doesn't really matter. What matters is they're going to accuse you of something.
Check out our other videos and playlists. Republic of Texas RT documentary. Texas and other American states is under a military occupation. The Republic of Texas Forum of 2016. And describe the kind of people who would thrive in independent Texas.
When they make their accusation, then your argument is, I don't care about anything else. Do you have jurisdiction to make that accusation? Okay, ma'am, what is your name?
Anna.
Okay, Anna. I'm going to ask you this. Are you married?
No.
Okay. If you were married, you would have a husband, correct?
I can't prove I'm not married.
I understand it, but if you were married, would you have a husband?
Yes.
Okay, you would be a wife, correct?
Correct.
Okay, if I'm married, I have a wife, and I'm a husband, correct?
Correct.
So your husband could take my wife anytime he wanted because he's a husband, I'm a husband, you're a wife, and she's a wife, correct?
No.
That's right. That's jurisdiction.
Yeah, I understand it. That's
okay.
A good analogy, but somehow I'm a little lost because why doesn't a company or an incorporated business have any authority to tax anyone? Why does that not prove it?
Because what happens is, okay, Title 26 is the Internal Revenue Code. If the IRS does not have jurisdiction, then the Internal Revenue Code does not apply. Now, I'm in Texas. What state do you live in?
New York.
Okay, so Texas, the Constitution of Texas is the supreme law of the land. Is Texas a supreme law of the land any good in New York?
No.
Well, yes, it is because it says supreme law of the land. See, that's what you're asking me. If the corporation is incorporated, does Texas law have anything to do with you in New York? No. So does Title 26 have anything to do with you? I don't know. If they have no jurisdiction, then Title 26 does not apply to you. When you ask, do you have jurisdiction, and they say yes, what do you have jurisdiction on? The Internal Revenue Code. Great. But does that pertain to me? Yes. How? Because we have jurisdiction. See, but they don't have jurisdiction if they can't prove it. So if they do not have jurisdiction, then Title 26 does not apply to you. And see, that's a simple argument. They either have it or they don't. If they don't have it, then that doesn't apply to you. Just like Texas law has something to do with New York.
Right. I think it's going to take a minute for that to seep in because
I understand, and it does because it's so simple. And this form 2, 4, and 5 is so simple. When you do it, the courts just roll over and bend over and give you what you want. Now you have a hammer that you can go and swing all you want. Why? Because they don't have jurisdiction. So Title 26 does not apply to you.
I think what you're saying is that if you just never mind the incorporation, it really we're just talking about jurisdiction, and that's the strongest card you could play.
That's the only card to play. That's correct.
Right, and I get that, but because you have an incorporation, it's like McDonald's and Burger King. They have nothing to do with each other.
That's exactly right. So it doesn't matter.
Why would they have anything to do with me? Because it's just a separate business, just like anybody else.
That's correct. That's exactly right. Now let me ask you a question.
Carrie?
Yes.
Carrie, can I add something to this? I think I can help.
What? Wait, I'm not finished yet.
Question. I think I can help answer Anna's question. I see what she's saying. I understand, and of course, where I'm at. We're on on the same page, 100%. But
let's look at it from just exactly who the IRS is and what they do. They are a legitimate tax authority. There are people in the United States that have a tax liability if they're involved in a revenue taxable activity, such as manufacturing of alcohol, tobacco, firearms, explosives, and other excise taxes listed on Form 820 in the Internal Revenue Code. They have a liability to file a return and pay a tax. Now, how does that prove? Well, the problem is, and where the jurisdictional argument comes in, is the fact that anytime anybody ever files a tax return, it establishes an individual master file created by the Internal Revenue Service. Remember, the Internal Revenue Service and everything they do is all a computer-generated program. So what happens is that individual master file, when you file a return, it's triggered and it creates an individual master file. And in order for that individual master file to create a 23C, all collection, all notices, all of it is done because you've been placed into a revenue taxable activity. If you order your individual master file, mine says that I'm involved in an individual business of manufacturing of pistols and revolvers. That's what my activity is. Now, I've never made a pistol in my life. So what happens is I've seen others such as sale of foreign earned insurance, coal manufacturing, alcohol, just various activities that are placed on your individual master file that categorize you as a taxpayer. Now, if you just work for McDonald's flipping hamburgers, obviously that's not a revenue taxable activity. But in order to get you implemented into the individual master file, creates a revenue taxable activity. That's why that each and everybody in the United States has got some kind of activity put in their master file to create a tax liability as a taxpayer.
Yeah, but the tax liability is actually created when you fill out the tax form. So when you sign a 1040, whatever forms you're signing, under penalty of perjury, that's when it becomes a taxable activity, because the top line in that form says taxable income or something to that effect, income, right? And that's a taxable activity when you sign it. If you don't sign it, it's not a taxable activity.
Well, that's true, and that's exactly what I said. When you file the tax return, you create an individual master file, and that IMF is implemented into a taxable activity. Now,
and then the whole system kicks in at that point.
Then the whole thing starts. Now let me give you an example of what I'm talking about. I've been doing this for 30 some odd years, and my kids, I've got 6 children. And when I started all this, they were young, and they wasn't working. All of them were under the age of 11, and so none of my kids filed a tax return when they did get old enough to where they could go to work. Well, guess what? Without filing a tax return, they never created a master file. Without filing a tax return, they could have a Social Security number, and they could work and be employed, and they filed an exempt W-2, and they never took anything out except for their Social Security. That's all they took out. They've never had a problem with the IRS, ever.
Because they never filed or signed a tax return, right?
Right. That's the whole key. They never filed a tax return. They never created an individual master file.
Right.
Well, right. Now, but the problem we're having here are these are people that have. So what
I
I'm trying to
understand
do,
that. But I'm
right,
answering Anna's question.
Right. I know.
Anna's trying to figure out how in the world does all this happen. And that's what I'm trying to explain to her. Without the filing of a tax return, you're going to have an individual master file. The minute you file tax return, then you create a master file, and that master file is actually alive. It's put you in a revenue taxable activity, and now you're liable for the tax.
It's still fraudulent because it's out of their jurisdiction. They don't have the.
Fraudulent. It's still fraudulent, and unless you are actually involved in a revenue taxable activity, and that's why they will not file a 23C.
And that ties right back to the jurisdiction that we were talking about earlier, right?
That's correct.
Exactly.
And see,
that's correct.
And when you go in and get your tax, when you get your court order, that's why you can use it to do whatever it is you need to do. I hope that made sense.
All right. Steve, can I ask you one last?
I went on the IRS website, and I saw that they don't provide the 23 fees any longer. Is that true?
That's correct. They don't do them because they can't sign them under penalties of perjury. And that's why they do not. They've stopped doing them. So they stopped doing them years ago. So
when did they stop doing them? What years? Do you know?
Probably in around 80.
Really? Okay.
Yeah. And
so my last two questions are short questions.
Yes.
Okay.
Okay.
Is that I have stopped filing, and basically, if I do as what this call is about, fill out the form, send it in. It's not like you have to. It's not a reaction. It's something you could do proactively.
Yes, and go in there and tell them you didn't get a notice of deficiency for however far you want to go back. Because once they come, now you have your paperwork. You just send it to them. I can't file because you don't have jurisdiction. Bing, it's done.
Right.
And
okay, so let me ask you this other question about jurisdiction.
Yes.
I mean, the court. You said get a letter from the district court. Is there a way to find out what court has jurisdiction over what matter, or?
Well,
that's confusing to me.
I know it is. If you go on the court website, it says this is a court of limited jurisdiction. See, that's all they say. So now that's there. On your website, it says you're a court of limited jurisdiction. Do you have jurisdiction over IRS? See, now it gives you a perfect segue to ask them. They will tell you they're gonna try to avoid it all they can. It might take 6 letters. It might take 10, but they're going to tell you because you keep asking them, and they will eventually say, "Okay, we're not going to be able to help you because." So I always ask them for help. How do I do it? If you go on any court,
is it specifically the district court or all the courts?
Well, no, you can go to each court you want to and do it. But if you go if the IRS comes after you and they indict you, they're going to put you in front of the United States District Court. The United States District Court is going to give you federal jail time. So if you have a letter from them saying they do not have jurisdiction, you don't have to worry about the indictment because when you show up, you hand it to them. You're done because they don't have it. And see, we're going and we're on offense. So then when you go to the tax court and they say the IRS doesn't have jurisdiction, now the court don't have it and the IRS doesn't have it. Why am I here? See, it's just a whole different lookout now. I'm not here to defend anything. I'm here to tell you, if you have it, show it to me. If you don't, see ya.
Right. That's
now,
really
Carrie,
brilliant.
The Constitution,
I love it.
The Constitution
this is my last
question. The Constitution is where your jurisdiction of the courts lie. If it's a state court, go to the state constitution, and it will break them down into JP court, county court, district court, appellate court, criminal appellate court, Supreme Court. If it's a federal case, then you go to the federal constitution, and it will break down all the jurisdictions of each of the courts.
Thank you for that.
One of the interesting things regarding jurisdiction, if you look at the different departments of the government, right, the departments of the government, and you might say pseudo-legally whether or not the IRS falls under this, but the departments of government, say the Justice Department. The Justice Department is supposed to investigate crimes within the government, right? They're not supposed to extend their powers outside of the government. You look at the different departments, the creation of those departments is where you find the jurisdiction associated statutorily with those areas, right? So you look at the Justice Department investigates crimes. The IRS is supposed to watch the internal revenue of the government. What does internal mean? It means internal, all the activities, right? When the government is, $20 trillion in debt and has entitlements of $56 trillion, the IRS is supposed to be watching that. The day before, September 11th, September 10th, when Rumsfeld declared that $3 trillion was unaccountable in the Defense Department, the IRS, the Internal Revenue Service, is supposed to be watching that. That's their job. So their jurisdiction does not extend to the point where they can exceed their position to address us when they're not addressing what they were fundamentally made to address, which is the internal crimes of the government. All the departments of the government are parts of the government that are to work within the government. So to make that move to extend their powers outside of the government is a very big and dangerous step to take. And that's where the jurisdiction falls, right there and then.
And that's the reason why if you go preemptively and get your letter, it's not a letter, get your court order from the tax court saying the IRS does not have jurisdiction. See, now when they come, it doesn't matter because now you have a winnable argument.
You're absolutely right, 100%.
The worst.
Steve, may I ask you a question, Steve? This is important. When you fill out the
question, please. Can I just finish my last?
You have probably asked 10 questions. I wanted to ask one.
I just want to finish the last one. I didn't ask 10 questions. So this is C. I'm looking at this order, and I just want to suggest something here. The capital order is underlined and it's spaced, and I'm looking at the law of language and the law of grammar. I'm wondering, have you ever heard of glossa?
Yes.
So I'm just wondering what this order really says.
Well, I can tell you what it does. Okay, you don't have to worry about that. Just you have it. It says what it says. It's no longer about taxes. Now it's about a contempt of court. That's how we're using it. Everybody who crosses over on it, they're in contempt of court. But I mean, I've had bank accounts reinstated. I've had banks not take my money. I've had we've done all kinds of crazy stuff with it because.
Right. Yeah, the last thing I'd say is that some of the I looked over some of the paperwork in there, some of the dockets. The judges that are listed on the site are not on the signed orders from the ones I've seen.
Right, because you looked at some older ones. They got new judges now.
I see. Okay. Well, no, actually, this was a recent one. It was 2017. Okay,
well, I don't know what to tell you about that other than it always gives it, the chief judge signs it. And when you call the court, they'll give you the ink signature from the judge. The wet ink signature will come to you.
Hey, Carrie.
Well, okay, I'm just trying to be informative. I'm not just sharing it. I'm not, I thought that was a little odd, so I thought I'd bring it up for the conversation.
Who was the other lady?
Okay, Gary.
Yes.
Okay. Hey, this is Dan. These people keep talking about jurisdiction in federal court. They want to go to the Constitution, read Article 3, Section 1. They've never been ordained, established by Congress. They're inferior courts. Read that. Right. It's very clear to them if they'd read it. And that other guy talking about IMF, if you look at that IMF, if you go into 1040s, they're only a tax class 2. They're not even irrelevant.
Right. See, once you start talking about jurisdiction, all the relevancy of the IRS goes away. They just don't. It's just. It's like grapes and apples. They're both fruit, but they're not from the same family, and that's basically what you're doing.
Yeah, I've challenged it under a criminal case. I challenged it under Article 3, Section 1, and they had to throw me back out on the street. There was nothing they could do to me.
Right.
Gary, thank you for your help. I so appreciate all your work and your brilliance.
It's no problem. And like I said, if anybody needs to get a hold of me, if you look at whoever invited you on here, Ed's got his email there. Email Ed, and he will individually send it to you, and you can send it to me. Yes, Ed?
We need to set this.
Lee, I have a question.
Recording.
All right.
Yes, I would like to ask. I would like to ask a question, Steve. When you fill out your form and they make a call to you, how are you? What questions will they ask? Do you know, and how are you supposed to answer their call, please?
They'll say, "This is so and so. I'm a prosecuting attorney for the Internal Revenue Service. Do you have any objections to me filing a dismissal of your case?" You say no, and then you hang up. It lasts about 30 seconds.
Thank you.
No problem. No problem.
Hey, real quick question on the letter to the U.S. District Court. You mentioned the one in Washington, D.C. Is that preferable, or should we use the one that would be?
Okay. The problem is the one in Washington, D.C. That's really the best one because they're all the same. But if you go to the one in Washington, D.C., if they don't have it, nobody has it. The one in your state doesn't have it. They're going to say, well, they do in Ohio or something. So I just found it worked better for me. That's all.
Gotcha. One other question. Getting the certified copy and getting the certified copy of the order, is that something that you would order through the U.S. tax court itself?
Yes. Once you get it, you just call them back, say, I want some certified copies. They give you the instructions, you give them your credit card, and they mail them to you.
Awesome.
Okay, Lee, I have a question. Our next call is going to be December 12th. I'm going to have to cut this one off.
All right. Is everybody...
Thank you all for calling.
Thank you.
Hey, Gary.
Yes.
Thank you.
Yes.
You still on the line?
Yeah, I'll call you back.
Thank you.
Okay. All right.
It was awesome.